Welcome, class. This is Political Science 200, American National Government. Today we will be going over the second half of your rights to life, liberty, and property. We will be discussing your due process rights and the rights of persons accused of crimes. Let's start with your due process rights. The 5th and 14th Amendments forbid the national and state governments to deprive any person of life, liberty, or property without due process of law. Right? So, the 5th Amendment prevents the national government from depriving you of life, liberty, or property without due process of law. And the 14th Amendment prevents state governments from depriving you of life, liberty, or property without due process of law. Now, what do you think due process means?
Proper.
Proper?
Yeah.
Oh, okay. So, certain proper procedures need to be followed before you can be deprived of your life, liberty, or property?
Yes.
Okay. All right. Good idea. Now, let's go back to something we talked about the other day. When we were talking about your rights to property. Say you own a car. Right? Can the government set speed limits on how fast you can go?
Yes.
Yes. So they are. Are they depriving you of some liberty?
Yeah.
Yes. Does almost every law deprive you of some liberty?
Yes.
Yeah. But as long as it has been passed by a legislature, right? Then it's considered valid, right? A lot of the time. And why do we have speed limits?
Because it protects you and other people from accidents.
Yeah, it protects the health, safety, and welfare of other people. Like we said in our previous lecture, a state's police powers are very broad. Right? So as we're having this discussion, just keep in mind, number one, a state's police powers are very broad, right? And number two, almost any law deprives you of some degree of liberty, right? But as long as it has been passed by either the state legislature or Congress and signed by the governor at the state level or the president at the national level, then that law has gone through the appropriate process, right? That is spelled out in either state constitutions or national constitutions. So just keep that in mind when talking about laws in general. But when we're talking about kind of the rights of the accused, due process kind of is in a different context, right? And so due process is going to kind of have different meanings, or it's just used in a different context when we're talking about the rights of the accused versus laws that are passed that may limit your liberty. Does that make sense?
Yes.
Okay. All right. So next thing is the Supreme Court has refused to give due process a precise definition.
Of course they do.
Well, of course they do, but keep in mind they can be very specific when they want to. And the Constitution is very specific when it needs to be. How old do you need to be in order to be a U.S., a member of the U.S. House of Representatives? 25. How much for U.S. Senator? 30. How much for President of the United States?
35.
35, exactly. Those are very clear, very specific, very concrete, right? And the Supreme Court has not been asked to interpret those, right? Because they're very clear. Now, due process is a very vague term, and the court has refused to give it a precise definition because they realize that it can change based on time, place, circumstances, available technology, that type of thing, right? Have a lot of people been sent to prison based on biological evidence?
Yes.
Their blood matched the blood type of the blood that was at a crime scene.
Yeah.
Yes, and was not the victim's, right? Oh, suspicious. Right?
Yeah.
and so this biological evidence is sitting in evidence lockers somewhere, right? And people are convicted, sometimes using this biological evidence. Well, now that biological evidence can be DNA tested, right?
Yes.
So now that that evidence can be DNA tested, the biological evidence, do you think that those who are being held, who are found guilty and are being held in jail, do you think they're entitled to a new trial because that biological evidence, now that it can be DNA tested, constitutes new evidence?
Yes.
You do?
I do.
Interesting. Why do you think that?
Because it's something new that came out, and it's really quite important.
Well, it's been sitting in the evidence locker for a while.
So, DNA doesn't, magically change.
Right. So it's the testing that's new, not necessarily the evidence.
Well, yeah. But the testing correlates to new evidence that can be brought into light.
Right. So in other words, now that the evidence can be DNA tested, it does constitute new evidence.
Well, yeah, because it's an entirely different thing.
It's an entirely different thing? Okay, I agree with you. I personally agree with you, right? Just so you know, former Chief Justice of our state Supreme Court, Sue Bell Cobb, what was her name? Cobb? I think her name was Cobb. Yeah, Sue Bell Cobb. Before Roy Moore, she came and gave a lecture at the University of Montevallo. She talked about this specific topic, and she said, as a judge, she did not feel it was her place to say that this biological evidence constituted new evidence now that it could be DNA tested. She felt that should be left to the legislature to decide. What do you think of that decision?
I don't agree that you guys are in charge of this kind of stuff.
Yeah, the courts are in charge of these types of things, right? Is Alabama a get tough on crime state?
Yes.
Yes, it's a very conservative, get tough on crime state. So are elected officials likely to stand up for the rights of the accused? No. So who do we count on to stand up for the rights of the accused?
The Supreme Court.
The Supreme Court, the courts. The courts have to stand up for the rights of the accused, right? But unfortunately, we have partisan elections in our state, which means that even our court officials have to pander to the public, which may not necessarily be good for protecting your rights. Right. Okay, so anyway, as I said, the U.S. Supreme Court has refused to give due process a precise definition because we just don't know how things change. But I think, personally, I think if a person is convicted using biological evidence, that biological evidence should have to be DNA tested in order to be used to convict someone. Okay, now, due process refers to rules and regulations that restrain people in government who exercise power. Restrains people in government who exercise power. And there's basically kind of two types of due process that the court has recognized: procedural due process and substantive due process. So procedural due process refers to the way in which a law is applied. Due process requires a procedure that hears before it condemns, proceeds upon inquiry, and renders judgment only after a trial or some kind of hearing. So again, trick question: where in the Constitution does it say you are innocent until proven guilty?
It does not.
It does not. Why are you innocent until proven guilty?
I do not know.
Basically because of the due process clause. You can't...
What's the due process?
Because of the due process clause. You can't be deprived of life, liberty, or property without due process of law. So, in other words, you're innocent until proven guilty, right? Why do you have the right to bail?
Because I'm not guilty.
Huh?
And it guarantees that I show up for my trial.
Yeah. And tied into exactly what we're talking about. Why do you have the right to bail?
Liberty.
Liberty, there you go. You can't be deprived of life, liberty, or property without due process of law. So the state may think you're guilty, but until a trial is held, until you have the right to confront your accusers in open court, until you have the right to tell your case in front of a jury of your peers, right? Until you have the right to subpoena witnesses in your defense, right? Until you have the right to cross-examine witnesses, until you have all these things, you can't be deprived of your liberty without due process of law, right? So all these things, the ones that are specifically mentioned in the Constitution, like the right to confront the witnesses against you, your right to a jury trial, excessive bail and excessive fines can't be imposed. Those are mentioned, but in a way they broadly constitute your due process rights. Yeah.
I have a question. So, if I get arrested or whatever, and I pay my bail, do I get my money back if I'm proved innocent?
Yeah.
That's what I thought. That's good.
Yeah. Absolutely. Now. Let me give you an example of when due process was abused. All right. And this is sensitive, and again, try not to offend anybody. But Natalie, have you heard of the Duke Lacrosse case? No. Okay. It occurred a little while ago now. But it's not like hundreds of years ago or anything. It was last 15 years type of thing. What happened was these young men that played for the Duke Lacrosse team were accused of sexually assaulting a girl. I think she'd been paid to be a stripper or perform or something like that at a party where there was a lot of drinking going on. Kind of like a frat party, team party, a lot of drinking going on. And these kids on the Duke Lacrosse team had been accused of sexually assaulting her, right? Okay, now, Duke Lacrosse.
About as preppy as you can get.
Yeah, okay, yeah. You've been reading The Outsiders or something, but yeah.
Sorry if anyone plays lacrosse, but I mean, it's kind of true.
Yeah, well, you don't play a lot of pickup games of lacrosse, right?
No.
It's very structured. The equipment is expensive. It requires a large, well-maintained field, nets, good coaching, so it's you don't get a lot of pickup games of lacrosse, right? So it's not like it's a higher income sport. Kids that play it tend to come from higher income backgrounds. Yeah. And this girl was racial minority, and so it kind of fit a lot of narratives, right? Rich, white, privileged kids, sexually assault, historically disadvantaged young girl, right? And so, their season was canceled, their coach was fired, and, my understanding is people were putting stuff up all around Duke, basically saying how disappointed they were in these kids, and I'm sure a lot of it got a lot nastier than that. And the kids were like, we didn't do it. We didn't do it. And the prosecutor was up for re-election. I don't know how soon, but, prosecutors have to run for re-election. And so the prosecutor wanted to go after these kids because it was such a high-profile case. And this taxi cab driver came forward and said, well, there's no way one of these kids could have done it. He was in my cab at the time that this supposedly happened. And I have a log of all the people that were in my cab and what times I carried them and that type of thing. And he was in my cab. I can show you my logbook. Well, the prosecutor looked into this guy's background, found out that there was, I think it was a warrant out for his arrest. And he said, if you come forward and testify in this case, then I'm going to execute this warrant and go after you.
Boo.
Boo, exactly.
Boo.
Right? Is that prosecutorial misconduct?
Yes.
Yeah.
Sure.
Absolutely, yeah. And again, I'm glad I'm not the one that had to deal with this case, right? Because there are a lot of issues going on. But it came out the kids were innocent. Now I'm sure a lot of things happened in that party that a lot of kids weren't proud of the next day, right? But the thing is, they didn't do anything criminal to this girl apparently, right? And so the prosecutor got disbarred. Yeah, the prosecutor got disbarred. And Duke University, which is a private university, they settled with the boys for an undisclosed amount. Yeah, and who knows how much that was, but...
I bet there was some white lacrosse mom going in there. Little boy! I bet they got a lot of money from that. Yay.
Yeah, I bet they did too. So... Now, let's go on to substantive due process. This places limits on what a government may do. An unreasonable law, even if properly passed and properly applied, is unconstitutional. For example, before 1937, the Supreme Court used the Due Process Clause to strike down minimum wage laws, maximum hour laws, etc. There's something called the substantive due process doctrine, right? And that's the idea that some laws inappropriately infringe on people's liberty, even if they've been passed through the normal legislative process. Right? They inappropriately infringe on people's liberty, right? So, a good example of this is Lochner versus New York, decided in 1905. Okay? Now, early 1900s, late 1800s, early 1900s. Historically, what do you know about the Supreme Court? Were they supporting businesses, banks, railroads, or not?
Probably, yeah.
Yes, they were, and that's why there were a lot of people making a lot of money, right? Like the oil industry, the railroad industry, the banking industry. They're making a lot of money during this time, right? And one of the reasons why is the court was very conservative when it came to its economic beliefs, right? It very much believed in a laissez-faire approach to the economy, hands off, right? So, 1905, Lochner versus New York. New York had passed a law limiting bakers to working 60 hours per week and 10 hours per day, right? And it was just bakers, right? Didn't necessarily apply to other industries.
That's weird.
Yeah, it is a little weird, but did the state legislature of New York obviously think it was a good idea, a valid law, a legitimate? Apparently, right? Because they passed it, right? So the case went to the Supreme Court, and the Supreme Court said this law is unconstitutional.
Darn right.
Well, interesting. Yeah, it's an interesting law, and an interesting ruling. In the case, the court said it interfered with your right to contract. Right? Now, as with your right to privacy and your right to an abortion, where does the right to privacy appear in the U.S. Constitution?
It does not.
It does not. Exactly, right? So a lot of people know about their privacy rights, their right to an abortion. They're less familiar with the Lochner decision, right? So that was 1905. And this decision was really typical of how the court was approaching laws that attempted to regulate the economy. Like I said, maximum hour laws, minimum wage laws, they interfered with the right to contract. So in Lochner, according to the court, how many hours a week could the owner of a bakery store make you work?
Hours a week?
Yeah.
Well, they said 60.
That's what the law said. What did the court say? Court said it's up to the person who owns the bakery and the person that wants to work for him or her, right? You decide how many hours you want to work and how much you want to be paid. That's not really up to government to decide. That's up to businesses and employees to work out. That's contract, right? So, the court applied that in a lot of economic cases before the Great Depression, and we'll get to that in a minute. They also applied it in other areas as well, though, right? There was a famous case, Meyer versus Nebraska, 1923, right? So 1923, historically, what had we just come out of?
1923?
Mm-hmm.
World War One.
World War One. Very good, right? So, was there a lot of anti-German sentiment?
Oh, yeah.
Yes, right? And so, yeah, so Nebraska passed a law that said kids couldn't learn German or any other language. It did say any other language, but German gets highlighted because it was obviously a response to World War One.
Yeah.
Right? Kids couldn't learn German or any other language under the 8th grade.
Are you serious?
Yeah. This state, the state legislature passed that law.
Wacko.
Yeah, it does seem a little wacko, right? Case went to the Supreme Court, and do you think the Supreme Court upheld or struck down the law?
Struck down.
They did strike it down, right? And they used a substantive due process doctrine approach to do it, right? And they said, this law inappropriately interferes with the right to acquire useful knowledge. Now, again, where in the Constitution does it say you have the right to acquire useful knowledge?
It does not.
It does not. But is that just part of what it means to be a human being?
Yes.
Yes.
Language.
Language, right?
The ability to communicate.
That's useful knowledge, absolutely, right? So does every society that we know of have a language?
Yeah.
Yeah, so learning a language is almost part of what makes us human, right? And so the court
Even
said...
animals can communicate.
Yeah, the court said you're going to pass a law that basically, strikes at the fundamentals of what it means to be human. That's just not right. So they struck that law down.
Woohoo!
Now, did the Nebraska legislature obviously think that was a reasonable law?
Apparently.
Apparently. A valid law.
Yeah.
A legitimate law.
Guess so?
Guess so. Yeah, they thought so. But the Supreme Court said no, right? So they said basically the state can't interfere inappropriately with any of your fundamental rights, like your right to contract, your right to acquire useful knowledge, your right to marry, your right to have children, and basically all the freedoms that are implicit in the concept of ordered liberty, right? So do you think the right to travel is a fundamental right?
Yes, that got taken away from me.
Yeah, it did. That's too bad. But anyway, so the court used the substantive due process doctrine to strike down a lot of laws during the early 1900s and the 20s, right? Then we had the Great Depression.
Uh-oh.
Yep. When did the Great Depression hit?
1929.
Very good. October 29th, 1929 is when a lot of people had marked the start of the Great Depression. But it was basically late 1929. That was kind of the end of the Roaring 20s.
Uh-oh.
And then
that was party time.
I know. And then the 30s were the Depression. And
the 40s were the war.
The people elected FDR in 1932. Did FDR promise a lot more government involvement in the economy to get the economy going?
Yes.
Yes. He won in 32 and took office in 33. And so from when he took office till he ran again in 36, he was proposing all kinds of government involvement to get the economy going. And Congress passing all kinds of laws to try and help him out. And what do you suppose the Supreme Court was doing to those laws? Maximum hour laws, minimum wage laws, things like that.
Striking them down?
Striking them down, absolutely. From up until 36, right? They kept striking them down. Then, who won the 1936 election?
36?
Mm-hmm.
Wasn't it FDR?
It was FDR again,
Then
exactly.
he died right after.
No. He won
That's
in
another one?
32, 36, 40, and 44. And he died right after
Yeah,
44.
because he had 4 terms, but he didn't
Yep.
really serve his
He,
fourth
he,
one.
he died early into his 4th term, yes. But the point is, he won in 32, so we need more government involvement in the economy. Won in 36, right? And so does it look like Americans want more government involvement in the economy?
Yes.
Yes, because he won by a landslide. And also, another thing was he pitched his court packing plan, right? And basically he said, I'm tired of all my proposals getting shot down by the court, right? And so, to the powers that be around him, he said, here's my plan. Congress is allowed to change the size of the Supreme Court. We got a lot of old members of the Supreme Court right now.
He cut them out.
And so he said, no, they're allowed to stay until they die or resign. But he said, they're getting old. They can't work as hard as they used to. And so for every justice over 70, I get to appoint a new justice. Let's pitch this plan, right?
Uh-oh.
And that was called FDR's court packing plan, right? And it would have led to him being able to appoint, I think it was like 6 new justices. And so he would have had enough justices on the court to basically pass anything he wanted. Exactly. Rule it was constitutional. So after the 36th election, FDR takes office in 37. Some cases start reaching the Supreme Court in 37. And, and this is a simplification, but they'd seen the light. And after 37, they started upholding a lot of these different programs and policies and proposals and laws, right? And it was called the Switch in Time to Save 9. To save 9 justices on the Supreme Court, right? And so that's why the textbook says, before 37, the substantive due process doctrine was used to strike down a lot of laws. Well, then we went through a number of years where cases were heard, the court was asked to declare some laws unconstitutional, and the court said we're kind of through striking down these laws by default. And so as long as the laws basically are rationally related to a legitimate government objective, our default assumption is to assume they're valid, and we're going to uphold them, right? Now, this kind of switched with Griswold versus Connecticut, and then Roe versus Wade. And with Roe versus Wade, the court, in essence, resurrected the substantive due process doctrine, right? So, again, in Roe versus Wade, Texas had a state law outlawing abortion. What did the Supreme Court do to that law? Struck it down. Why?
Because it interfered with a person's liberty.
Liberty, exactly. Excellent. And so they resurrected the substantive due process doctrine again. And they struck that state law down on 14th Amendment grounds. No state shall deprive any person of life, liberty, or property without due process of law. So That's why some justices, Rehnquist dissented in that case, and Byron White dissented in that case. 2 justices dissented, and they said, if people don't like this state law, what should people do?
Make an amendment.
Well, see, they're even more simple than that. They said if people don't like this state law, then they should elect different state legislators.
Oh.
Or run for the legislature themselves, not make up new rights that aren't necessarily clearly listed in the Constitution. Make sense?
Yep.
Okay, good. All right. Now, let's talk about the rights of persons accused of crimes. If you're in my constitutional law class, if you're in my constitutional law class, you've heard some of these before, but let's talk about the rights of persons accused of crimes. Protections from unreasonable searches and seizures requires police, if they have time, to obtain a valid search warrant issued by a magistrate after the police indicate under oath that they have probable cause to justify its issuance. Right? Okay, so in general, do police need to get a search warrant before they come into your home?
Yes.
In general, yes. Do they have to have probable cause in order to get that search warrant?
Yes.
Okay, what is probable cause? How is it established?
Reasonable doubt that a person...
Reasonable suspicion.
Oh, reasonable suspicion, not reasonable doubt. Reasonable suspicion that there is something in another person's property that could be dangerous.
Yeah. You have to show that there's a reasonable suspicion that a crime has been committed or that evidence of a crime will be found. Right? Yeah, there you go. Right? Okay, so in general, police have to get a search warrant in order to enter your home. Let's talk about some exceptions to the warrant requirement. Do the police need a search warrant if you give consent for them to enter your home?
Nope.
Do they need a search warrant if they are in hot pursuit? If they've seen you commit a crime and you run into your house, do they need a search warrant?
Nope.
Nope.
Just walks right in.
Right. It's not like your house is home base and tag and you make it a house and you're safe. If they're in hot pursuit, they are allowed to continue following you. Right? Can the police act quickly in order to avoid destruction of evidence?
Yes.
Yes, right? So there was a famous case dealing with this, talk about my con law class, where a guy was suspected of strangling his wife, and he went down to the police station for questioning. He showed up and there were dark marks under his fingernails and on his fingertips.
Like dried blood.
Like dried blood, exactly. So this guy probably wasn't the sharpest knife in the drawer, but he shows up with these dark marks under his fingernails and on his fingertips. The cops said, we need to take a sample from underneath your fingernails. And he said no. And the cops did not have a search warrant. And he was using his keys to try to remove the material from underneath his fingernails. So the cop said, well, we're taking a sample whether you want us to or not. We don't have time to get a warrant. So they took a sample. They found fibers of his wife's nightgown, skin tissue, and blood that matched her type of blood. Right.
That seems like pretty condemning evidence.
Yes, exactly. And so he tried to appeal his conviction, saying, they gathered evidence without a search warrant. The case went to the Supreme Court, and the Supreme Court said, you have to act quickly in situations like this. It was perfectly reasonable for the officers to gather evidence, right? Okay, now, let's talk about the exclusionary rule for a minute. This is the requirement that evidence unconstitutionally or illegally obtained be excluded from a criminal trial. Where in the Constitution does it say evidence that is illegally obtained is not admissible at a trial?
It does not.
It does not, right? The Fourth Amendment says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Right? So you're protected against unreasonable searches and seizures, but the Constitution doesn't state clearly how that's going to be enforced. Right? So, say in England, the cops, come in and they conduct an illegal search, and it's obvious the person is guilty. In England, what will happen in that situation is the person will be prosecuted for whatever they were doing illegally, and the person is allowed to sue the police. Right? They don't necessarily have the exclusionary rule. Right?
Yeah.
But we do here in the United States. The exclusionary rule developed in a case called Mapp versus Ohio. Dalry Mapp was kind of a shady character. As my dear mother would say, she had her fingers in a lot of pies.
Yeah.
She had a lot going on. And apparently she was engaged in a number of illegal activities. And she had someone in the inside in the Cleveland Police Department because she kept getting warned every time the cops were going to come over with a warrant. And she'd clean the place out, remove any evidence or whatever. They just couldn't catch her. And they knew she was doing a number of illegal things. So anyway, in this one particular instance, she was suspected of harboring a fugitive from justice. The cop showed up without a warrant. Knocked, asked to be let in. She said, "Where's your search warrant?" They said, "We don't have one." She said, "Well, you're not coming in without a search warrant." So they went back to their cars. They waited several hours. Then they knocked again, said, "Here's our warrant," and they threw a paper in her face. It wasn't a search warrant. One was never presented at trial. They barged in. It was a really chaotic scene. But at the end of the day, the police never produced a search warrant. And they never explained why they didn't get one. Right? So, they entered her house illegally, And once they were inside, they didn't find the fugitive from justice, but they did find a number of obscene films, which it was a violation of Ohio law to possess at the time, right? There'd be a later court case where the court says, what obscene materials you have in your house is your business. But that's a later case. At this time, it was a violation of Ohio law to possess obscene materials in your home, right? So, the case went to the Supreme Court, and the Supreme Court said the exclusionary rule, which used to just apply to the federal government based on earlier court rulings, the exclusionary rule now applies to the states. And it said basically the Fourth Amendment, which protects you against unreasonable searches and seizures by the same document, makes the exclusionary rule applicable to the states. Right? So, does the Fourth Amendment guarantee that evidence that is illegally obtained is inadmissible in court?
Yes.
Why?
Because
We have 3 branches of government. Tell me from a 3 branches of government standpoint why evidence illegally obtained is inadmissible in court.
Because it infringes upon a person's liberty and privacy.
It's even simpler than that because the Supreme Court said so.
Well then.
Who interprets the Constitution?
The
Supreme Court, right. So even though the words exclusionary rule do not appear in the in the Constitution, right? If evidence is illegally obtained, is it inadmissible in court?
Yes.
Yes. So again, I'll give you another chance to answer. Why?
Because the Supreme Court said so.
There you go. All right, very good. All right, now the right to remain silent. We're moving on. Next topic. The right to remain silent helps prevent forced confessions and strengthens the principle that a person is presumed innocent until proven guilty. Okay, so again, if you've had me for constitutional law, we've covered some of these topics, but we're covering them briefly here in American national government. The right to remain silent is most commonly associated with the Supreme Court case of Miranda versus Arizona. Right? Miranda was a 23-year-old indigent, nearly illiterate truck driver. And he was arrested because he was suspected of kidnapping and raping a woman. After 2 hours of questioning, he confessed. Case went to the Supreme Court, and the Supreme Court ruled his confession is inadmissible. Right? Now, just so you know, he was later retried without the confession and found guilty. A lot of people forget that fact. They assume he just walked scot-free, right? But he didn't. He was retried without the confession. He was found guilty and wound up going to jail. But anyway, let's stick to the constitutional principles here. The court said this confession is inadmissible. Why is it inadmissible? Because it's the responsibility of law enforcement to make sure that people know that they have the right to remain silent. Okay, so, trick question again. Where in the Constitution does it say you have the right to remain silent?
It doesn't.
It doesn't. It says you can't be compelled in a criminal trial to be a witness against yourself. You can't be compelled in a criminal trial to be a witness against yourself. What does compelled mean?
Forced.
Forced. Was there any sign that he was forced?
No.
No. And that's what some conservatives don't like about this case, right? Is that the cops did everything they were supposed to do. They questioned the guy. He voluntarily confessed. But the Supreme Court said, sorry, it's up to police to make sure that people know that they have the right to remain silent, that they have the right to an attorney. If people can't afford an attorney, one can be provided for them, right? Do you see this basically in every cop show?
Yes.
You have the right to remain silent. Yes. So, there it goes. Anyway, so those are your Miranda rights. They came out of that case, and the police can't assume that, number one, you know your right to remain silent, right? They're not allowed to assume that. And the court in that case also said you need to know... Oh, well, let me rephrase this. One of the reasons why you need to be read your Miranda rights is so that you know the adversarial process has begun. The cops are no longer your friends. They are no longer there to protect and serve you. They are there actually to build a case against you and to try to prosecute you. So you're their prime suspect, and they're no longer there to protect and to serve. The adversarial process has begun. Make sense?
Yes.
All right. And also, just so you know, since we've talked about very broad themes in this course, the founders were well aware of oppressive regimes, and they knew that forced confessions occurred very often in oppressive regimes. So they wanted that totally taken off the table. So you can't be compelled in a criminal trial to be a witness against yourself. Okay, now let's discuss a couple things. Fifth Amendment provides that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. It's referred to as the double jeopardy clause, right? You can't twice be put in jeopardy of life or limb. Who has superior resources, individuals or the state?
The state.
The state, the government, because the government has the power to tax. They potentially have unlimited resources, right? So the founders, again, knew a thing or two about oppressive regimes, and they didn't want the state to be able to go after you again and again. Because eventually, if the state had it out for you, if they were just going after their political enemies, they could just keep prosecuting you and bleed you of all your resources, right? So the government has one shot at you, right? So do prosecutors have to be strategic about how long they want to take gathering evidence before they indict someone and bring them to trial? Yes, definitely. It's a strategic decision. Okay, now let's talk about something that I think is interesting. Double jeopardy does not prevent punishment by the national and the state governments for the same offense. Now let's read the original words of the Constitution. No person shall be subject for the same offense to be twice put in jeopardy of life or limb. What does twice mean to you?
2 times.
2 times. If you're tried by the federal government and the state, are you being tried 2 times?
Yeah.
Yeah. I actually disagree with how this clause in the Constitution has been interpreted. I think the federal government and the states are going to have to work it out between themselves who gets their shot. You know, but I personally, again, you don't have to share this, I personally think it's unconstitutional for the federal government and the states to go after you for the same crime. So again, we mentioned Derek, the laser pointer, is a violation of federal law because he interfered with an aircraft while in operation. It was a violation of state law because he shined a light in the eyes of an officer while in the line of duty. Could he potentially have been prosecuted for both?
Yes.
Yes. See, I think that's wrong. That's one offense. The government should get one shot at you, whether it's federal or state. But that's not how the Supreme Court has interpreted it. I'm not on the Supreme Court, and the Supreme Court has said double jeopardy does not prevent punishment by the national and the state governments for the same offense. Okay. Also, it does not forbid civil prosecutions even after acquittal in a criminal trial for the same conduct. Right? So this is what happened to O.J. Was he found innocent in the criminal trial?
Yes.
Well, he was found not guilty, right?
Yeah.
There's a reasonable doubt. Then he was retried again in a civil court, and he was found guilty, and then he had to pay damages to the families of the affected victims. See, in my personal opinion, that's just fine, right? Because the only danger in a civil suit is you'll lose money, right? There's no risk of going to jail. But I'm opposed to the idea that both the federal government and the state government can go after you for the same offense. I personally think that's wrong. Last legal term we need to discuss is indictment, and that's a formal written statement from a grand jury charging an individual with an offense, also called a true bill, right? So if you're indicted, that means you're formally charged with an offense. Make sense?
Yes.
All right. Well, it's been fun. Have a great weekend, class. Take care and stay healthy. Bye-bye.